Well, hello, COS supporters. Welcome back to another edition of COS Live. My name is Andrew Luce. I'll be your host. And of course, I'm joined by my co-host, Rita Peters, who is also the Senior VP for Legislative Affairs. Rita, it is great to be back with you again. How are you doing today?
I'm doing great. I am really happy to be back together again for COS Live, Andrew.
That's right. Well, we got another committee hearing today. We're going over to Ohio. We're going to the House Government Oversight Committee, and we're going to be listening to our Convention of States Resolution HJR2. That committee is going to be considering that alongside HB 67, which is our 34 Ready bill. So we're going to get into the specifics of our legislation there and what the committee is going to be discussing, because it's not going to be just proponents today, but we'll get to that in a little bit. But for those who are just tuning in, who are new to the movement, 20 states have passed our Article 5 resolution for proposing constitutional amendments under three areas: limits to federal spending and limits to federal power, plus term limits on elected officials. So those are the three planks of our resolution. And boy, if we had an amendment for in one of those categories, it would just be incredible. If we got all three, it'd be even better. It takes 34 states to get to a convention. That's the magic number we need to hit. As soon as we get 34 states on board, then Congress is compelled to call a convention where we can start discussing these ideas for bringing back good governance in the United States. So, Rita, can you get our guests caught up with where we're at in Ohio and how we got to this committee hearing where we're at right now?
Yeah, and before I do that, Andrew, I just want to point out that today's hearing will be a little bit different than a lot of the other committee hearings we cover, because Ohio, as we've mentioned before, they have multiple committee hearings. It's not just one hearing with supporters and opponents and the sponsors. They have a separate hearing for sponsors, supporters, opponents. They like to break it up. So today's hearing is going to be the hard one to watch because it is the opposition only hearing. So after, we're going to do our best to listen and not scream, not throw things, not bang our heads against the wall, Andrew. But after the hearing, we're going to come on and Andrew and I will do some debunking, some myth busting, and just some commiserating about the terrible and ridiculous things opponents like to say about Convention of States, right?
Right, Rita. I can't guarantee that I won't take off my shoe and throw it at the camera because of all the things that we hear today. But I'm real excited, though. It is fun to debunk these things and to go through all of the craziness and bring some sanity to our guests who are going to be watching this. So super excited that we get to do it again, even though we do this every single year and hear the same exact myths, lies, and other things that are just make you want to bang your head against the wall.
And the truth is, Andrew, every once in a while, somebody comes up with something new and creative. Yeah. So that's was it last year we had an opponent diagram the sentences of Article 5, and, we were able to put her whole diagram up, and yeah, that was a new one. But anyway, the hearing, for better, for worse, is going to start in a few minutes in Ohio. So Producer G's keeping an eye on that. And as soon as it starts, we're going to take you live to the hearing room. But before that happens, while we're waiting, let's get up to date on what's going on in Ohio. Last year, we brought you coverage from the same committee. It is a 2-year session in Ohio. So that's why we're still going on, still the same resolution, same bill, even though we've had hearings here before. So this is actually the 4th hearing in this particular committee. They've already had their introductory sponsors only testimony. They've also had our proponents only hearing, where our grassroots team just knocked it out of the park giving their testimony. And we are expecting the committee today to limit the opponents in the same, or at least a similar way as they limited the proponents, which was up to 5 testifiers, and they gave them 3 to 5 minutes each. However, we should keep in mind that committee members are free to ask questions of the people who come to testify. And so that can extend the time. We don't really know how long this is going to take. Frankly, I do hope these committee members challenge some of the things that we'll hear from the opponents, but we'll see whether that happens or not. First, we expect the committee to hear the Convention of States resolution, that's HJR 2. The committee also will hear testimony against our 34 Ready bill, which is HB 67. And 34 Ready is what we call Convention of States actions, model legislation for governing the process for an Article 5 convention as far as that state is concerned. So how the commissioners will be selected by the state legislature, how the oversight of the delegates or commissioners will work once the convention is going on. That sort of thing is all addressed in the 34 Ready bill, which is HB 67 in Ohio. We do not expect a vote today. That's not usually how it goes in Ohio. But the big news is that following today's hearing, this committee would officially be free to vote at any time. So stay tuned for that. It's a pretty exciting place to be in the Ohio legislature. We've been waiting and having hearings over and over again, and there are a lot of good signs that this may actually be the year for a committee vote, followed by finally floor votes in Ohio, which would be amazing.
Yeah, I'd love to see that. I know our grassroots would love to see it, especially our great grassroots in Ohio. I'm sure they are just clamoring for a floor debate in the Ohio legislature. Rita, going back to what we were saying about the disinformation, it's going to be really hard to get through it. But it is good that we do this, because the disinformation that we hear, it's not just isolated in Ohio. We hear it from every corner of the United States. Every state team has had to grapple with all of the disinformation that is out there, all of the lies that are out there, like the runaway myth, calling the 1787 convention a runaway and saying that the founders disobeyed their commissions and drafted a whole new constitution when they weren't given authority to do that. We hear that over and over and over again. So it is helpful to go through oh, and look, we are actually in the committee. So we'll have to wait on what I was saying until we get back. And once it wraps up, we'll debunk all of the crazy stuff that we hear, Rita. Can't wait for that.
Here.
Representative Pazili is checked in. Representative Rader. Here. Representative Sims.
Here.
Representative Stevens.
Here.
Representative Troy is checked in. Representative Workman.
There is Representative Humphrey as we speak. It's been a crazy day here at the State House with the State of the State got moved to today. And that is why a lot of members have been rushing around to different committees and different meetings that have been rescheduled and scheduled again. Today we have two pieces of legislation before us, HJR number 2 and House Bill 67. I will ask the witnesses that are coming in today that plan to speak for both, if you would like. While you're up testifying for the first one, I think we have a list of some people who have decided to submit opponent testimony for both of them. If you would like, you're allowed to spend an extra minute, 2 minutes to go ahead and talk about why you're against the other piece of legislation as well. It would kind of save time on both ends if you would like. Again, we have a 5-minute policy on testimony for when you are at the microphone. But other than that, we will move right ahead and go on to House Joint Resolution number 2. I will call up Amanda Sabrowski for testimony. All right. Looks like Amanda's not with us, so we'll move down the list. Is Dr. John Diamond with us? Dr. John, welcome to committee. You may proceed when ready.
Thank you, Mr. Chairman, members of the committee. My name is Dr. John Diamond. I was born about a mile down the road here at Grant Hospital in 1965, graduated from West High School in 1983, joined the United States Air Force 6 days after high school, spent 8 years in the military, took an oath to support and defend the Constitution, And that's why I'm here opposing SJ2. We've got, this is very, very dangerous. I was a theologian before I became a constitutional scholar. I wrote both my master's and my doctoral dissertation on the founding of this nation. And I think that's the only seminary dissertations that were ever written on things outside of the scripture. And I actually go back to the Protestant Reformation because that's really where America's history starts. Europe was on fire with a bunch of religious persecution. The founders all kind of fled here to flee from that. And then they gave us what we would consider to be our wonderful, wonderful First Amendment. But now that and pretty much everything else is at risk. If we call this constitutional convention, it can't be, it will not be limited. One of the things that a couple things I want to bring to your attention, the National Constitution Center, which is in Philly. I spoke out there last year. And as one of the speakers, the National Constitution Center actually has what they call the Constitution Drafting Project. And it starts off by saying we're here to celebrate the greatest document of human freedom, but then they turn around and they have what's called the Constitution Drafting Project, where they ask teams of scholars to submit their ideal constitution. Now, I believe we have an ideal constitution. The one the founding fathers gave us, the ones that just escaped all the tyranny and just shed blood to give us everything and all the freedoms that we have. I think they know a whole lot better than we do why our Constitution was founded, why it was created, what it was seeking to prevent. So I only printed off the progressive and the conservative. That way this wouldn't be seen as bias in either way. But both of those do not limit the power of the federal government, it expands it. And I'm only going to read the First Amendment, the new First Amendment, under the conservative one. Okay? It says, all persons have the inalienable right to the free exercise of religion in accordance with conscience. Neither the states nor the United States shall make or enforce any law requiring with specific purpose of inducing any religious practice or favoring any religion over another, or prohibiting, impeding, or penalizing the free exercise of religion. Sounds great till you get to the next line. Except where it is necessary to secure public peace and order and comparably compelling public ends. Okay, our Constitution says Congress shall make no law. The new Constitution says Congress shall make no law except, and then they give you a whole bunch of ambiguous stuff that you could basically shove anything into. And I've submitted these to you. These are actually long, fully written constitutions. I only submitted like 2 pages because that's the one I'm focusing on here. And then here's the progressive one. No one shall be subject to coercion, which would impair his freedom to have or adopt a religion or a belief of his choice. Freedom to manifest one's religion or belief may be subject only to such limitations as are prescribed by law. So both of these proposed constitutions don't say Congress shall make no law. They say Congress can regulate this. All right, and this is even close to what it says about the Second Amendment. And I've highlighted that on your paper since I'm not going to have time to talk about this. When I listen to some of these people talk, they're constitutional scholars, you can go back and read the Constitution. If you don't know why it was drafted, you don't understand the safeguards they put in place. I'm here to tell you right now that this is a Trojan horse. And if you understand the story from antiquity, the Greeks tried to take down the city of Troy for 10 years, put it under siege. And they said, this ain't working, we got to try something different. So in one night, they built a horse. They said the war's over. They got in their ships. They slid away, and they were deceived into opening those gates and letting the people in, the enemies in. And it destroyed it in one night. Okay? This Convention of States is a Trojan horse. And they have absolutely no way at getting in our Constitution unless you open the gates. You are the last line of defense to keep our Constitution from being meddled with. So I just want to thank you for your time. My time's up here, unless anybody has anything for me.
Thank you, sir, for being with us today. Is there any questions from members of the committee? Seeing none, thank you for, is there a question? Brief, please. But yes.
Thank you. So you said it's a Trojan horse, and I just want to understand, from your understanding, what would the process be if enough states were to actually pass a convention of states and require that there be one? What would the process, how many different layers would there be before there could actually be constitutional changes? Can you help me understand that? Because I think it's not just the states. I think it also involves Congress, and then we have to ratify. But I want to hear from your perspective, what are all the different hoops they would have to jump through to make these changes stick?
Yeah, I think actually one of our speakers is going to speak on to that. One of the papers I gave you, though, and again, this is not partisan red or blue, but I sent you one of the things where New Jersey, the Democrats in New Jersey just submitted a proposal for a con for reproductive rights or abortion. Okay, so you can imagine what a con could look like as defined as this party is. I'm not Republican, I'm not Democrat, I'm an American who took an oath to defend the Constitution. This nation is so polarized, it's not funny, right? And you try to get all those people up with views that are so different from another. I can't imagine what would come out of this thing. If it would even go through, if there would be such infighting. My biggest thing is they get in there and they change the rules. And they get like half of the states to agree to it. Because they changed the rules the first time. If you remember the Articles of Confederation, they needed all 13 states to ratify that. They got in there and they changed it. So don't let them convince you that they can't do that again. Read Madison's Federalist 40. They did it. We've got a great big gigantic book sitting right here that is a government document that says Madison says we were beyond our purview. We did what they said we're not supposed to do. So someone might be able to speak to the nuts and bolts of that. It wouldn't be good. My biggest fear that it would be a civil war. And that's if they get up in there and half the states go for it and half the states don't. And especially if the one states are going, you lied to us. You said we'd have control of it. You said we'd control our reps. You said it would have to take 3/4 of the states. And now half of you are agreeing to it and half of you are not. I mean, they put out a movie, Civil War, here not too long ago to kind of prime the plug a little bit. We need to do whatever we can do to avert that. All right?
No, thank you, Dr. John Diamond. Members, we're going to be here all night if we're going to ask all these questions. So, Representative Rader.
Short question. One thing that I'm concerned about is foreign influence in particular in these situations. We see what's going on. Maybe you could just speak to that briefly if you're concerned about if we do this, we crack this open, we've got groups like AIPAC flooding money into congressional races to try to get folks elected. What would happen? Are you worried about that foreign influence?
Oh, absolutely. I'm worried about foreign influence on our elections, on everything else. And I think both sides are. Both sides are worried about foreign interference in our elections. How much more one of these where people can have their palms greased a little bit to support a particular topic. I mean, we're here today right now because of the people we send to Washington already don't obey the Constitution. Revising it and doing anything else isn't going to change that. All right, it's us that has to stop them from violating that.
Representative Sims.
Thank you, Mr. Chairman. Thank you so much for your testimony today. In your words, and I'm going to paraphrase, is your biggest fear this will be a runaway convention? Could you speak to that?
Yeah, absolutely. And again, I think we've got a book. Someone's going to testify. We got this 800-page book here that the government prints and puts out for judges. There's only, 4,900 of them put out every year. And right in the beginning of it, when it talks about the convention, it says right in that government document that it was a runaway convention and that they went far beyond what they were called to do.
Just quick follow-up.
Yes, but very brief. Very brief, please.
They made me forget my question. Thank you, Mr. Chairman.
Okay. Thank you, Dr. John Diamond, for being with us today and for your testimony.
Thanks, everybody.
Sue Barber? Is Sue Barber with us today? Okay. What about Ellen Horton? Hi, Ellen. Welcome to committee. You may begin when ready.
Thank you very much. Thank you, Chairman Hall. Ranking Member Humphrey, okay, and members of this committee. I appreciate the opportunity to address this committee to testify against HJR 2. And I intend to clarify that Article 5 of the Constitution of the United States identifies Congress as the authority that controls all aspects of a constitutional convention. I'm going to quit pretending I can see. Okay. All right. No state's role is identified prior to ratification in the, addressing the Constitutional Convention. Even the ratification process, however, belongs to Congress. As Article 5 itself says, the mode of ratification may be proposed by the Congress. The Legal Services Commission of the Ohio General Assembly came to the same conclusion. Okay, they acknowledged the ultimate control by Congress and recommended the congressional method of amending the Constitution, which is the tried and true method that has taken us this far. And because their reason was the role of the states in convention is not defined. Article 5's only mention of state authority prior to the ratification process addresses the application process, not the amendment process itself. And in their analysis of HJR 2, the Legal Services Commission, this is Ohio General Assembly's a team of expert legal entities, okay, submitted these comments. First, the General Assembly recommends that when Congress determines how many proposed amendments are to be ratified, it chooses ratification by the state legislatures. Okay, I'm going to stop there for a minute to point out the fact that the General Assembly identifies Congress as the entity that determines how many proposed amendments are to be ratified. Okay, so when that happens, they prefer that it chooses ratification by the state legislatures. Unfortunately, the ratification options are not chosen by the states, but by Congress. And again, Article 5 says the mode of ratification may be proposed by the Congress. Do the states have to accept the choice made by Congress? We have no way of knowing until it happens. It's never happened. We have no frame of reference. To date, all formally proposed amendments to the U.S. Constitution have been proposed by Congress. This method has proved itself successful 27 out of 27 times, and we found that even when we've made a mistake, this very same congressional method provides the remedy to the problem. Amendment 18 was abolished. The transfer and sale of toxifying liquors, okay? That amendment was repealed by Amendment 21. So the method, well, that's self-explanatory. I'm sorry. All right. The LSC also noted that a convention of the states for amendment has never been held under Article 5. Now, this should end the comparison between interstate conventions and an Article 5 convention. It's an apples and oranges comparison because Congress has no role in an interstate convention. Okay, the U.S. Constitution doesn't specify how an Article 5 convention must be conducted or how its delegates will be chosen. Okay, so further, the Constitution does not indicate whether the states that apply for a convention may limit the scope of amendments that the convention is to propose. And there are bills in this building that are being considered now to try to choose to tell how delegates will be chosen and what amendments will be considered. The Constitution itself says that is not an option. Okay, before I run out of time, I would like you to look at the diagram, if you don't mind. Okay, I was an English teacher, can you tell? Okay, the top part deals with the method of ratification that has been done throughout the history of this nation. Okay, so I'm just going to cover that part up. Okay, and we'll look at the bottom part, which is the part that applies to the Article 5. Okay, the Congress, on an application of 2/3 of the several states, shall call a convention for proposing amendments. Makes it very clear that it is Congress that shall call this convention. It is not the states. So Article 5 demonstrates the role of Congress without, I'm sorry, let me just finish. The Congress shall, in the first method, propose amendments to the Constitution, or by the second method, shall call a convention for proposing amendments. I thank you very much. I'm open to questions.
Yes, thank you for your testimony today. I envy your cursive writing. Mine has never been that good.
I taught that too.
Representative Gross has a question for you.
Thank you, Chair. I must say Mrs. Horton. It is an honor to have my constitutional teacher here today. And for those of you who don't know, many, many years ago, at least a decade, Mrs. Horton taught me a course on the Constitution.
I
for
told you
which
I was a teacher.
Yeah, and she did an amazing job, and she still does teach. So I wanted to ask you, just to repeat, and I know you kind of said this, but proponents of this bill cite the large number of previous interstate conventions as examples and precedents for how an Article 5 convention would be conducted. Don't these previous conventions provide the answers to the questions and the rules and the procedures?
Do the interstate convention?
Yes, they
Absolute-
use the example of interstate conventions as examples and precedents on how an Article 5 convention would be conducted at the federal level. And so then they say, well, this is an example of how it would be at the federal level. Don't these conventions provide answers to the questions about the rules and procedures, or do they not?
Well, actually, that's wishful thinking because Congress, that leaves Congress out of it completely. And so what role does Congress have if an interstate convention is just as effective when it doesn't involve Congress at all? So if it's a federal issue, then Congress has to be involved. And where does that leave the authority of the states? According to the Constitution, it minimizes, almost disappears the influence of the states. So in answer to your question, it's Congress that handles it. Thank you for your question.
Thank you, Representative Gross. Ranking Member Humphrey.
Thank you, Mr. Chairman, and thank you, Ms. Horton, for being here today. We certainly appreciate really your expertise, but I have a question based off of some of the things that you mentioned. So you mentioned that the Convention of the States has never been held underneath Article 5. But given that Congress has proposed amendments 27 times without a convention, why do you think the lack of precedent automatically means the process may be too dangerous to consider?
Actually, I don't believe that that was my intent. I didn't mean to say that. Okay, all I'm saying is we have no idea what would happen. And there's a risk in that very fact. You know, if the Congress is in charge, and I have read, okay, my evidence from the Constitution that says that Congress is in charge, there's a definite risk of the state's influence being minimized. Okay, thank you for your question.
Representative Gross. Or Representative King, I'm sorry.
Oh.
I'm sorry, Representative
Thank you,
Gross.
Chair, and thank you for being with us today. So I've heard that proponents of this bill, along with others, they realize they may not get a convention of states, but that if there's enough resolutions, they will force Congress to act. And so I guess my question is, isn't it a safer route? And I think you did mention this in your testimony, to go through the, I guess, the amendment or the committee process with a bill and vet it. And I guess, what are your thoughts on that? Is that not the safer route to go? There seems to be some risk with the unknowns if we do the Convention of States.
I thank you for that question, Representative King, and I think that you have pretty much reiterated my concerns because we have no idea what will happen. I hesitate to say that because I think it would be total chaos. And I think the uncertainty of everything is the reason for that. It's clearly written in our Constitution that Congress is in charge, and you can't force Congress to defy the Constitution. You know, no resolution has the legal authority to do that, and that would just bring chaos.
Thank you.
Thank you.
Representative Sims, did you remember your question?
No, thank you.
Okay. Well, thank you so much for coming in today.
Thank you for having me.
Next, we will call up Jeannie of Vanchich. All right, we'll move on down the list. Alicia Healy. Hello, welcome to committee.
Thank you. Chairman Hall, Vice Chairman Ferguson, Ranking Member Humphrey, and members of the House Government Oversight Committee. I am Alicia Healy, and I gladly give my testimony in opposition to House Joint Resolution 2, calling for an Article 5 convention to amend the Constitution of the United States. I am hopeful that you, the members of this body, have good intentions, that you truly love our country as I do, and want to see it great again. We all have our own ideas on how this can be achieved, but we must go back in history and remember from where we have come. We are celebrating the 250th year of our independence as a nation in 1776. And since 1789, we have been operating under our Constitution. Think of this, almost 2.5 centuries we have thrived under our Constitution. Why would we want to substantially change it and by the method prescribed? I believe the Constitution is divinely inspired. At the Philadelphia Convention in 1787, after much debate, Benjamin Franklin called for prayer, saying, "Unless the Lord builds the house, they labor in vain that built it." God heard and answered the prayers of our forefathers in that time. The question is, what kind of people are we today? If we are honest, the problem lies not with our Constitution, but with ourselves and with corrupt individuals we elect. Ben Franklin said, "When the people find that they can vote themselves money, that will herald the end of our republic." Though he thought a general government, well administered, would be a blessing, he feared it could end in tyranny if the people became corrupted. Could we be at that point today? At our founding, we had statesmen who feared God. Now we have an elite political class that think they are gods. The founders believed you were to serve a short time in office and then go back home and work. Today, representatives think that the people should serve them. They stay in office and retire and live off the people for life. We had patriots who loved their country, had great pride in being Americans, and wanted people and the nation to prosper. Today, we have too many in our Congress who hate our country, yet want all the benefits this country offers. The founders united our nation with a government of, by, and for the people, not the elite, rich, or powerful. So what's the remedy? John Adams said, "Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other." First, we must return back to God and be a nation under God again. Psalm 33:12 says, "Blessed is the nation whose God is the Lord." Second, Thomas Jefferson said, "An educated citizenry is a vital requisite for our survival as a free people." So we must bring back civics and the incredible history of our republic. While I agree that the states must use their power to rein in the federal government, the question is, do we call for an Article 5 convention under the culture we have today? We only have the history from the first convention when we operated under the Articles of Confederation. That first convention gave us the Constitution. What will the second give us? All those in favor of this may have good intentions, but it's been said the road to hell is paved with good intentions, which often lead to unintended consequences. An Article 5 convention will not solve the problems to what ails our government and nation today. Only the people with God, I must add, is the only sure reliance on the preservation of our liberty. Let's preserve our Constitution and our republic. Don't change it, just obey it. Our Constitution has stood the test of time. Let's not risk the danger of an Article 5 convention. The answer to the question, do we call for an Article 5 convention, is a resounding no. Vote no on House Joint Resolution 2. Thank you.
Thank you for your testimony today and for being with us. Representative Gross has a question.
Thank you so much. Mrs. Healy, do you have a title? Dr. Healy. Can you,
Question.
in regard to an Article 5 convention, can you guarantee this committee that an Article 5 convention would not propose amendments affecting fundamental rights such as free speech, gun rights, or elections.
No.
Follow.
Thank you.
All right. Thank you for coming in today. Next, we will call up Joseph Healy. Is Joseph Healy okay? Welcome to committee. You may begin when you're ready.
Thank you. Oh, hang on. Go. Good afternoon, Chairman Hall, Vice Chairman Ferguson, Ranking Member Humphrey, and members of the House Government Oversight Committee. There's a broad range of ideological groups who have issues of concern who would want a seat at the table at a constitutional convention. Americans of every political persuasion are concerned about protecting their rights or demanding action on their issues of concern. Many of them have joined the chorus to call for a convention. They will not be kept out. Could elitist powers pit us against each other and use us as pawns to destroy our Constitution? And yes, there are power-seeking elites who have schemed for a long time to replace our Constitution altogether. We can go back to the early 20th century. Woodrow Wilson thought our Constitution was outdated. An obscure man named Edward Mandell House wrote a book, and Wilson read it. It was called Philip Drew Administrator. It was a fictional story about a military coup in America where the Constitution was suspended and an administrator was put in charge of a bureaucratic dictatorship. Wilson loved it. House became his chief advisor, and his book became the blueprint for the fundamental transformation of America for decades to come. Have you heard that phrase somewhere? House also founded the Council on Foreign Relations, which to this day is the central hub of the globalist deep state in America. Rexford G. Tugwell may be unknown to us today, but he was a prominent official in FDR's administration, part of his brain trust and an architect of the New Deal. Decades later, he published a book called The Emerging Constitution, in which he proposed a replacement for the U.S. Constitution entitled A Constitution for the New States of America, which I've attached to my testimony. There was definitely no right to bear arms in it and had a heavy emphasis on emergency powers. He was working for a think tank funded by the Ford Foundation, a tax-exempt foundation also linked to the CFR and the Trilateral Commission. Around the same time, Zbigniew Brzezinski, try to pronounce that, who was associated with the globalists at the CFR, wrote a book, Between Two Ages, Between Two Ages, where he repeatedly called for the scrapping of the Constitution and established a technocracy to rule the world. He helped form the Trilateral Commission with David Rockefeller and became Jimmy Carter's national security advisor. He pushed global free trade and initiated the offshoring of American manufacturing industries to other parts of the world. Fast forward to today, Robert P. George has authored a new constitution called the Conservative Constitution. Robbie George, as his associate Mark Meckler calls him, is on the Convention of States Legal Advisory Board. Robert P. George is also a member of, you guessed it, the Council on Foreign Relations. His proposed constitution essentially nullifies the Second Amendment and has other problems. But the purpose here is not to examine the merits of his work, but to illustrate that these people really intend to radically change and replace our Constitution. And they need the opportunity of an Article 5 convention to carry out their plot. There is a wide variety of groups calling for an Article 5 convention. Conservative balanced budget groups, high-profile politicians like Rick Santorum, and media pundits like Mark Levin and Glenn Beck, but he changed his mind. Support the idea. Also, liberal groups like Wolfpack, who want to end corporate personhood, change campaign finance laws, as well as intellectuals like Columbia legal scholar David Posen support a convention to make our institutions more democratic. Globalist George Soros, a member of the CFR, is also funding the Move to Amend coalition, and on, the Sierra Club, you name it. This is definitely a top-down, money-driven attempt by the ruling elites to push the idea of an Article 5 convention. One has to wonder if the low-level activists really understand what they're being bribed to support. And what about the politicians? They say that money is the mother's milk of politics. are the elite advocates of a con showering politicians with money to buy their support? Where's the money coming from for the Convention of States group? Despite Mark Meckler's claim that most of his donations are $5 and $10 contributions from little old ladies on a fixed income, filings show that the COS fundraising entities under Meckler's control get 63% of their income from a few high dollar donors, averaging about $100,000 each. The identity of these high dollar donors is unknown. It's not public. We call it dark money. I'd like to know who these people are. So the choice before us is clear. We must use the state's muscle, state power to enforce the Constitution or be seduced by the moneyed interest to go down the primrose path of a constitutional convention. Please vote no on House Joint Resolution 2. Thank you very much.
Thank you for coming in and for your testimony today. Representative Gross has a question for you.
Thank you, Chair. Thank you, sir, for being here. COS Staff Counsel Robert Kelly, 11 years ago, not only did he purport to support an Article 5, but he also supported tapping into Article 1, 2, and 3, so not just 5. So my question for you is, does Congress have the authority to set the rules of the convention?
Well, you know, the Constitution seems to indicate that they call the convention, and, you know, under the elastic clause or the necessary and proper clause, it does say that they can make all the laws necessary and proper for the carrying to execution the foregoing power. So technically they could get into the weeds and make a lot of rules about the convention that they call. But as I say, the only precedent we have is the 1787 convention, and that there were strict rules for that over the delegates too. And yet the delegates threw out the rules, and they said they were appealing to the supreme power, the power of the people itself, to reframe their government. So I would say Congress does have power to make rules, but they aren't necessarily going to be obeyed.
So thank you, Chair. Chair, thank you so much for that answer. So if Congress then has the authority, then it's not really in the hands of the states, correct? You know, Congress under the Constitution seems to have the authority over the convention. So no, it's not really, the states are saying we can set all the rules. That's probably not true. So just to clarify.
But, you know, they might be able to buck the system and do what our founders did. I'm just saying it could be a free-for-all.
So just to clarify, is it okay?
Yeah.
So just to clarify, the states are not controlling the process, correct?
No, as much as they want to try to, the strict wording of the Constitution gives Congress the power to control the process as much
Thank you,
as they
sir. Thank you.
will to do so.
Thank you for coming in and for your testimony today.
Thank you.
Next, I will call up Tom Rice. Is Tom Rice with us today? Now, Mr. Rice, I see you want to testify for both. Would you like me to give you just a few extra minutes at the end of this testimony to touch on both?
I'm going to pass. If I could take, there are a few details I would like to touch upon with HB 67. So
Yeah.
if I could defer and just have my 5 minutes, that'd be great.
5 minutes
For HJR2, please.
Okay.
Is that okay? Okay. Well, Mr. Chairman and members of the committee, my name is Tom Rice. I'm a former American history teacher, now retired. I reside in Pickerington, Ohio. I want to thank you for the opportunity to testify against House Joint Resolution 2. This piece of legislation calls for the convening of an Article 5 convention for proposing amendments to the Constitution for the purpose of imposing fiscal restraints on the federal government, limiting the power and jurisdiction of the federal government, and congressional term limits. Concerning the first two parts of this proposal, the Constitution, as it is already written, already restrains the federal government and limits its power and jurisdiction. According to the supreme law of the land, the Congress can only spend taxpayer money to provide for the common defense and general welfare as described in Article 1, Section 8, Clauses 1 through 18 of the Constitution. Additional handcuffing of the federal government is also provided within the 10th Amendment, which declares that an item not indicated in the Constitution, the federal government cannot become involved in this area, such powers being reserved exclusively to the states or to the people. In short, the 10th Amendment is telling the federal government, if we forgot anything, you can't do that either. Let's look very quickly at the third part of House Joint Resolution 2. This calls for congressional term limits. In actuality, we already have term limits at the congressional level. They're called elections. Every 2 years in the House of Representatives, every 6 years in the Senate. The proposed bill, we do not really need the proposed bill. The deficiency that we have right now in America is not in the Constitution. The deficiency lies with those unfaithful congressmen who putting their left hand on the Bible and raising their right hand. These unfaithful congressmen who fail to keep their oath of office to preserve, protect, and defend the Constitution. So help me God. Finally, I fear convening the Article 5 convention for any reason whatsoever due to the danger of a runaway convention. The best example of a runaway convention would be the 1787 Philadelphia Convention, whose job description was, and I shall quote, for the sole and express purpose of revising the Articles of Confederation. Upon commencement of the convention in May of 1787, America's founding fathers boarded up the windows at Independence Hall in Philadelphia, held their deliberations in secret, and they trash canned the Articles of Confederation, and they hammer out the Constitution. The result of this runaway convention, like I said, was, thank God, was very fortunate for the American people, was the Constitution. Would we be so lucky in a modern day convention? I fear we would not. Even President Ronald Reagan, he also feared the concept of a runaway convention. In the public papers of President Ronald Reagan, dated July 2nd of 1982, the Gipper said the following, and I'll quote, "Well, constitutional conventions are prescribed as a last resort because once it's open, they could take up any number of things. In short, the Constitution needs to be obeyed, not dangerously tinkered with by modern day innovators." And hoping if there's a question and answer session, you want to ask me hopefully more about this concept of congressional term limits. But for the aforementioned reasons, I urge you to vote in opposition to House Joint Resolution 2. Thank you.
Thank you, Mr. Rice. Representative Gross.
Thank you, Chair. Thank you, sir. I don't know if you're Dr. Rice, but to me, you're Dr. Rice.
My grandfather was.
Thank you so
Just
much.
call me Tom, please.
Thank you for your testimony today. So in kind of sort of in the vein of a quote unquote runaway convention, if the delegates violate the rules, the limits set by the states, who has the legal authority to remove them or invalidate their proposals?
You've got everything upside down. And this
Okay,
is
go
why
ahead.
I deferred on HB 67. Under the Constitution, Representative, the convention has two jobs. Number one, they apply for a convention. Okay. And if 2/3 or 34 states agree with this application, then Congress then calls a convention for hearing amendments. Okay. The second job the states have is once the delegates to the convention are selected, and they're selected not by the states because those powers are not given to the states in Article 5. Please read Article 5. It's only like 139 words, okay? But they don't have the power, the states don't have the power to, once the convention is applied for, then the Congress, like it's been said, they'll write the rules, the regulations, selection of delegates, you know, the duration of the convention, the funding of it, you name it. And then once the amendments are hammered out, then the states have the power to say either, yes, we approve the amendments that have been sent to us, or we say thumbs down. They have no other power. You know, the 13 years I taught American history, I would say to my students, beware of three basic principles. Number one, Constitution. is the supreme law of the land. Premise number 2, words have meaning. Premise number 3, the Constitution means what it says. Those were the powers that the states have are a convention. They apply for a convention, and then once the amendments are sent to them, they say either yes or no. They play no other role in the convention process. They don't have that power.
Just very briefly, please.
Thank you. So the states have no ability to choose what delegates would go in from their state.
That's correct, because those words are not given to the states in Article 5. Where do we find, though, that the power then, who would make those determinations? This gentleman before me, Mr. Ely, gave you the answer. It's in Clause 13 of Article 1, Section 8, the necessary and proper clause, okay? Congress then has the power to do these things. And we know an Article 5 convention is constitutional, but the rules and regulations, they're not indicated in Article 5, are they? So who has those powers? The Congress has these powers, okay? But then even on top of that, guess what? The Congress could lay down rules to the delegates at the convention, and they could scrap the entire rules, the whole set of rules. It's a Pandora's box, okay? The fear of a runaway convention is very, very dangerous. And you know what? Why take that fear and that chance? You got the restraints, you got the handcuffs right here with the Constitution. Thomas Jefferson said it best. He said, in questions of power, let us hear no more of confidence in man, but bind them down from mischief with the chains of the Constitution. We have the solution right now. You know, both sides of this controversy, they just want constitutional government. If you want it, then implement it, exercise it. Thank you. Thank you.
Thank you, Representative Gross. Representative Troy?
Thank you, Mr.
I'm sorry.
Oh, that's all right. Thank you, Mr. Chairman and Mr. Rice. And as I can tell, you're a student of history. So I guess I don't disagree with your premise, but if the idea of an Article 5 convention is so abhorrent, why do you think Madison included that in the Constitution when it was written? I mean,
I see it as an alternative, a worst case scenario to, and Representative King had referred to, and she didn't use these words, but there's 2 ways to amend the Constitution. There's the congressional route, where 2/3 of the House and 2/3 of the Senate.
And 3/4 of the states.
And then once those are, and you see, but that's a situation where one amendment is provided, okay? And it can be limited. And then 2/3 the House, 2/3 the Senate, they approve it, they send it to the states. Typically in the 20th century, they gave the states 7 years. And then if 3/4 or 38 of the states then agree with that amendment, okay, then that amendment is part of the Constitution. But you can limit the process with the congressional amendment route. With the convention route, it's anything goes. Keep in mind, the Articles of Confederation proposed in 1777, not approved until 1781. Maryland becomes the last state to approve it. It required unanimous consent, all 13 states. Okay, then in Article 13 of the Articles of Confederation, to amend the Articles of Confederation, you needed unanimous consent, all 13 states. Okay, what's the Philadelphia Convention do? They trash can the Articles of Confederation. They give us the Constitution, but they move the goalpost in the process, don't they? Because we look at Article 7 in the Constitution, it says if 9 states approve the Constitution, it's ratified. So I hope I answered your question there, sir.
Thank you, Representative Troy. Thank you, Mr. Rice, for your testimony. We'll bring you back up here shortly. Next, we'll call up Sandra Ryan. Sandra Ryan with us today. All right. What about Barbara?
Burkhart?
Yes.
Her husband's in the hospital. She couldn't make it.
Okay. Well, we will be praying for her and her husband. Mr. Tuttle, I believe that brings you up to the microphone.
Thank you, Mr. Chairman. I'd love a chance to answer the James Madison question from just a moment ago, if that's possible later. But Chairman Hall, members of the committee, thank you very much for allowing me to testify against HJR2. For the sake of brevity, I'm going to be pretty blunt. Please, as Mr. Rice said, do not open Pandora's box on our Constitution by supporting an experimental convention with potentially serious unintended consequences. We can be sure that a convention would be a prime target for highly partisan activist billionaires and a complicit media to try to derail and insert their own agenda. Whether it's term limits, balanced budget, or any other intended reason, an Article 5 convention would be a huge risk. So let's start with what we know to be true for sure. It's an undeniable fact that there has never been an Article 5 convention in our history, and there's never been any valid precedent, which I'll talk about in a second. It's an undeniable fact that there are no agreed upon rules for a convention, as been brought up before, which was confirmed by the Congressional Research Service in a series of reports between 2012 and 2017. We don't know who the delegates would be. We don't know what the voting rules would be. We don't know what the rules for delegate selection would be, or even how many delegates there would be. There are 0 rules that are agreed upon. There are suggestions that have been made, but there are no agreed upon rules. We don't even know when a convention would happen. How long would it take to get 34 states to apply for this resolution? They've got 19 or 20 now. One of them may be relitigated, but that took 14 years. So we're not likely to have a convention for another 10 years at least. What's the political landscape going to look like in 10 more years? It's an undeniable fact that there is a long list of credible and compelling experts who warn us that a convention would be a huge risk. Compare them with the list of, respectfully, politicians and talk show hosts that the Convention of States lobby likes to promote. At least 3 of our founders, 3 Supreme Court justices, and I've got a list here of more than 45 legal and constitutional scholars across the country who say that a convention cannot be limited and it's a very dangerous risk. Unfortunately, in the midst of all of this, the assumptions that the Convention of States lobby is asking you to make are also, unfortunately, just simply false. They're asking you to believe that there have been many previous conventions, to an earlier question, that create an understanding of how a convention would be run. There is no valid precedent for an Article 5 convention among them. It turns out, and please follow up and ask me more about this due to a lack of time, but those conventions were very small. There were a small number of states. There was only one convention that had more than 9 states attending, except for the 1787 convention. And most importantly, it was not a federal function. None of those were federal functions, and federal functions are governed by the Constitution and the Supreme Court, which I will address much further in my HB 67 testimony. So while convention lobby assures you that the state legislatures would have complete control over delegate selection and convention rules, the courts, it turns out, have resoundingly ruled against that claim. And I will address that directly in my HB 67 testimony in a few minutes. So I believe that it would be very unwise for this committee, or for any state legislature for that matter, to allow activist billionaires and radical partisans on either side of the political spectrum to get their hands on our Constitution. Because as Mr. Rice and several of the other testimonies have stated, once that constitutional convention is convened, it cannot be controlled. And that's what the legal scholars have told us over and over again. So I urge you to vote no on HJR2 to protect our Constitution from this very risky experimental convention. Thank you again. Look forward to answering any questions.
Thank you, Mr. Tuttle. Is there any questions? One, please. Please.
Thank you, Chair. Thank you so much, Mr. Tuttle, for being here today. What do you mean by unintended consequences to a convention, and what do you see most likely as an unintended consequence?
Representative Groth, thank you for that. through the chair to Representative Gross. I see two types of unintended consequences. One of them is that, and I'll address this again in my HB 67, if a convention is convened, there are going to be a lot of legal battles. There will be, the courts will be clogged with discrepancies and disagreements on who's in charge of what, as we've talked about. The Constitution itself is just not clear. So we're going to bog down our courts and put the courts in a very difficult situation. And please forgive me, I don't know for sure whether there are any lawyers in the group, and you may know even if you're not a lawyer, about the political question doctrine. The political question doctrine goes back to Baker versus Carr a number of years ago. The Supreme Court said there are some discrepancies between branches of government that we don't want to get in the middle of. And so we're going to stay out of it. It's non-judiciable, is what they said. That's the political question doctrine. A battle between the states and Congress would certainly fit that bill and would be a very good reason for a lot of court intervention. And secondly, and most importantly, we could get amendments that we don't expect. So not only could they go beyond what is in the limits of this HGR2, but think even within HGR2 limits, it says limit the power and jurisdiction of the federal government. Think about how broad that is. They could limit any function of the federal government, and that would be within the bounds of this resolution. So for example, think of just a couple of examples. They could limit the federal government's jurisdiction over immigration law. They could limit jurisdiction over drugs and legalized drugs. They could limit the jurisdiction over virtually anything. A big one would be, think about the right of reproductive freedom shall not be infringed. Okay, that's one example. So anything that you could limit the federal government, a really big one, the Electoral College. The Electoral College has to be approved by Congress, as we saw on January 6th, several years ago. Congress has to approve the votes by the Electoral College. If to take Congress out of the Electoral College would limit the jurisdiction of the federal government. And if you went to a national popular vote, for example, which 18 states have already signed on to, very likely, that's another example of an unintended consequence. So I hope that helps.
Thank you, Mr. Tuttle. Before Representative Troy, do you have a question?
Please ask me about James.
Yeah, Mr. Tuttle actually said he would love to
Yes.
address the James Madison question. And I'm reading some of his background here. And if he is called the father of the Constitution,
Yes, sir.
and he did vociferously argue against including this, how did it happen? I mean, was this one of these compromises that had to be agreed to get the Constitution through? Like,
Right.
no matter how big your state is, you get 2 senators, right?
Yes, sir. So through the chair, Representative Troy, James Madison actually argued vociferously against the wording of Article 5 on September 10th and September 15th, according to his own notes. He said that the language of Article 5 should be reconsidered. It needed to be redone. And he said the reasons were because we don't know what form it would take and we don't know what the rules would be. That's in Madison's notes. So he was definitely against the language that we ended up with Article 5. And by the way, George Mason, who was considered the father of the convention route in Article 5, remember, he stormed out of the convention and refused to sign it. So he must not have been too sure that this would be a remedy for an out-of-control government. So Madison was against it. And the reason he probably wasn't able to stop it, they overruled him. This is September 15th. The convention ended on September 17th. They were stuck in a hot room in the middle of summer in Philadelphia, and they were anxious to get out of there, and they didn't feel like arguing anymore about it. They kicked the can down the road, although Madison was against it. So that would be my suggested answer to that.
Thank you, Mr. Tuttle. I want to make sure I do this correctly. Is there anybody else here to testify against HJR2 in person? Okay, so that will conclude the 4th hearing for HJR2. Mr. Tuttle, stay up there because House Bill 67 is called up next for its 4th hearing. And you may continue your testimony on this as well.
Thank you, Mr. Chair. Again, members of the committee, appreciate being here. I've spent an awful lot of time on this. Been studying Article 5 for more than 4 years after I retired. Also a Constitution instructor along with Mrs. Horton. But we appreciate this opportunity to testify. So this bill, HB 67, is a relatively new tactic by a well-funded lobbying organization to try to convince legislators like yourselves that an Article 5 convention would be safe because you can appoint and control the delegates. This bill is just a placebo, however, to make you feel better, but does not solve the problem. Here is the problem. As I alluded to before a convention was convened, there would be a lot of court activity and court challenges, probably lots of them. So what are the courts going to say? Do we have any clues to what the courts would say if there was a challenge about states' ability to appoint delegates or control the delegates? Absolutely. First, hopefully you all have had a chance, or maybe not, to look at the LSC analysis of HB 67, where they point out that in Article 2, Section 27 of the Ohio Constitution, it specifically says that the Ohio legislature may not appoint anyone other than those specifically granted for them to appoint in the Constitution. And the LSC points out that that is not in the Ohio Constitution, that they can appoint delegates to a constitutional convention. And therefore, we're looking at this being totally, this would violate the Ohio Constitution. Any attempt to appoint delegates by the legislature would almost certainly be struck down in the state of Ohio. Second, federal courts have clearly demonstrated that they would never allow states to limit or control a convention or their delegates. For more than 180 years, in at least 7 major Supreme Court cases specific to Article 5, federal courts have held that Article 5 is a federal constitutional process. States may participate by applying for a convention or ratifying amendments, as was pointed out earlier, but they cannot limit, control, condition, supplement, or dictate the rules of the amendment process. They certainly cannot be, this certainly cannot be ignored. And I would hope, due to time, someone would ask a follow-up about those court cases. Finally, there's ample reason and precedent to suggest that Congress, as been mentioned before, actually has the power to determine delegate selection. So here we're talking about the courts again. Whether based on the necessary and proper clause, which was brought up before, which is cited by the Congressional Research Service and multiple legal scholars as granting this power to Congress, or whether you're looking at an extensive body of case law from federal and state courts. Like it or not, Congress will almost certainly intervene with backing from the courts. After applying for a convention, the states can only sit back and watch and wait to see what happens. Let me give you a quick example of what I'm talking about here by a federal case that says what I just pointed out. An example is Dillon versus Gloss, 1921. And here's what it said, quote, "As a rule, the Constitution speaks in general terms, leaving Congress to deal with subsidiary matters of detail as the public interests and changing conditions may require. And Article 5 is no exception to the rule." Now, there are numerous other court cases, Idaho versus Freeman being a big one, that use that same terminology. Congress has the ability to append subsidiary matters of detail to their federal function, which in this case would be a call for a convention. So they could say how many delegates they're going to be, where the delegates are going to come from, what the criteria for delegates would be. So neither the U.S. Constitution nor the Ohio Constitution grants these powers to the states. And across every major Article 5 case, the Supreme Court articulates a consistent and clear principle. When the Constitution assigns a federal function, states may not control, supplement, constrain it unless it is explicitly granted that power in the Constitution. This is a federal function, not a mere gathering of states or an interstate convention, as many predecessors have been. States cannot control or limit a federal function. So please, members of the committee, do not be fooled. This bill will not be enforceable. It will not make a convention safe. It's nothing but a placebo to help convince uninformed legislators who haven't had the opportunity to hear both sides that a convention could be controlled and limited. It cannot be enforced. So thank you for your time. I would be very happy to answer any questions.
Thank you again for your testimony on House Bill 67. Representative Workman and then Representative Gross.
Thank you, Chair. Thank you, sir, for being here to discuss this bill. This is a little bit new to me, so learning as we go here. But I guess I question here, one of the pillars, I believe, of the Convention of States is full autonomy on our elected officials. So one of the things that they address is a bureaucracy, an unaccountable bureaucracy. So this bill in particular seems to delegate the state legislators' authority over to a advisory committee. Can you talk a little bit more about the process of that authority?
Thank you, Representative Workman, through the chair. Basically, the ability of the states to get involved in the selection or control of delegates in any way is prohibited both by the Ohio Constitution and by a body of case law that says that they can't get involved at all. So whether or not they do it through a commission, which, and I'm very familiar with the resolution, says they're going to create a commission. The commission's going to keep a really close eye on the delegates to this convention. And if they do anything wrong, they're going to either recall them, they're going to correct them, or they're going to slap them with a third-degree felony, right? None of that is possible because both the Ohio Constitution and an extensive body of federal case law says that the states cannot limit or control their delegates in any way. I hope that answers the question.
Thank you, Representative Workman. Representative Gross.
Thank you, Chair. Thank you again, Mr. Tuttle, for being here. In the last HB 67 testimony hearing, Dr. Ferris answered a question about state control of delegates. With a recent Supreme Court case, Chiafalo versus Washington, as a precedent for state control of the delegates to a convention, is Chiafalo not a decisive precedent?
Thank you, Representative Gross, through the chair to Representative Gross. I believe you asked Dr. Ferris that question, and he responded with Chiafalo versus Washington as the precedent. Chiafalo versus Washington, I've done extensive research on Chiafalo versus Washington, and it is definitely not a precedent that is valid in any way. You know, most interestingly, and let me pull this out, it turns out that the Convention of States has a legal team, and that legal team has participated in 6 federal and state court cases on various aspects of the Constitution since 2020. Chiafalo versus Washington was in 2020. It was their first of 6. Now, they wrote amicus briefs in all 6 of those federal and state cases, arguing before, in this case, the Supreme Court in Chiafalo versus Washington in 2020. If you, one of the reasons I was surprised that Dr. Ferris would bring that up is in their actual amicus brief, this is the amicus brief from Convention of States on Chiafalo versus Washington, their conclusion reads as follows, and I quote, "The court should carefully limit its holding to presidential electors, clarifying that the decision is not applicable to others performing federal functions." They're clearly saying here, Supreme Court, do not allow Chiafalo versus Washington to be used as a precedent for any other type of federal function. Yet here they are using Chiafalo versus Washington as a potential precedent. I would suggest that shows, I mean, again, I said I was going to be blunt, and a bit of desperation on their parts if they couldn't come up with a better case to use as a precedent than one where they had argued the exact opposite to the Supreme Court. Secondly, Chiafalo actually strengthens our argument that states cannot control a convention. In Chiafalo, Supreme Court Justice Kagan, who wrote the deciding opinion for a unanimous court, pointed out that the ability to support and appoint, or excuse me, ability to appoint and direct electors, which is what was at risk in that case, came directly from the explicit language of the Constitution. Article 2, Section 1, Clause 2 of the Constitution says that state legislators shall appoint electors in a manner of their choosing. And they used that explicit language in the Constitution in Chafalo to give electors, to give states the powers over those electors. She also pointed out in that decision that there were several other places in the Constitution, don't want to take too much time, Article 1, Section 3, Clause 1, Article 1, Section 4, Clause 1, that gives states specific powers over federal functions. Notice that there is no such power given to the states with respect to an Article 5 convention. And I think the absence of that power granting in the Constitution itself speaks volumes. When the founders wanted to give the states control over a federal function, they put it explicitly in the Constitution, and it's simply not here. And one
Just
one
please
last
be
thing.
brief, please.
Yes. Chafalo versus Washington was, as I mentioned before, the first of 6 cases that the Convention of States legal team argued before federal and states courts. It's important to know that not only were their arguments rejected unanimously in Chafalo versus Washington, so they got the conservatives and the progressives on the Supreme Court to agree on something, which is very hard to do. That's how far off they were. But they then went on to be rejected in 4 of the 5 additional cases that they've argued since 2020. So the COS legal team arguing cases before the federal and state courts have lost 5 out of 6 times. I would suggest that that's not a very good recipe for an organization that I would want to put too much credibility in interpreting the Constitution, or frankly, in predicting what the courts are going to say about an argument that may come up. Thank you.
Thank you, Mr. Tuttle, for coming in today. Mr. Rice, if you'd like to come back up to give your 5-minute testimony. I was trying to get as many testimony in without questions because members had to leave, so that's why I apologize for. Mr. Rice, begin when ready.
Okay, thank you, Mr. Chairman, members of the committee. I'll try to keep my comments brief. I appreciate this opportunity to testify against House Bill 67. This measure sometimes is referred to as a faithful delegate bill. It calls for the convening of an Article 5 convention for proposing an amendment to the Constitution for the purpose of the states establishing appointment procedures for what we call a con or constitutional convention. Under Article 5 of the Constitution, the states simply do not have this power. This proposal is a fairy tale. According to Article 5 in the Constitution, concerning a convention, the states have only 2 powers. Power number 1, they apply for a convention. Power number 2, they either approve or reject amendments that have been submitted to them. And let's examine more in detail these 2 premises. Premise number 1, the states apply for a convention. If 2/3 or 34 states agree to this application, then Congress shall call a convention for proposing amendments. Premise number 2, the states either approve or reject amendments that have been submitted to them. After the convention determines the amendments, they are submitted to the states for ratification. If 3/4 of the states or 38 of the states, their state legislatures or state conventions ratify these amendments, they become part of the Constitution. They become part of the Constitution provided the delegates to the convention do not alter this rule of ratification. In Article 5 of the Constitution, the states have no additional powers to exercise during a convention. The 1787 convention was a runaway convention, as we've discussed previously. This event, such an event is not unprecedented in American history. It happened nearly 240 years ago and could unfortunately happen again, perhaps subjecting the American people to many unpleasant surprises and unintended consequences. We know that a convention is authorized in Article 5 of the Constitution, but the rules, regulations, and procedures are not indicated in Article 5 of the Constitution. Concerning a convention, who would make the following determinations? The funding of the convention, its venue, length of duration, selection of delegates, rules of ratification, and all other rules and regulations, etc. The answer to this question simply is the Congress. We find that in the Constitution, in Article 1, Section 8, Clause 18, this power is given to the Congress because we find in Clause 18, just referred to, that Congress is given the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution. These powers belong to the Congress, not to the states. In short, the Constitution needs to be adhered to, not amended. For the aforementioned reasons, I urge you to vote in opposition to House Bill 67. Thank you.
Thank you again, Mr. Rice, for being with us today. Any questions? See none. Thank you for being with us, and thank you for your testimonies. Pierre Wolf. Pierre, I believe you're the last one today, and there might be one or two more, but Pierre, welcome to committee. You may begin when ready.
Thank you very much. What an extraordinary opportunity to be here. I'm a naturalized citizen, and I think that this is an incredible process, and the expertise that has come before me is just overwhelming. My name is Pierre Wolf. I'm a resident of Columbus. I'm here today to provide opponent testimony on Ohio House Bill 67 because it is inseparable from and intended to facilitate Ohio House Joint Resolution 2. While HB 67 is presented as a procedural measure establishing how Ohio would appoint delegates to Constitutional Convention, its real purpose is to prepare the state for participation in Article 5 Convention of the States. That
Andrew, the testimony has become repetitive at this point. We're hearing the same things over and over again. So producer G has opted to stop. It sounded like there were only one or two left anyway. If you are just now joining us, you've been watching an Ohio House Government Oversight Committee hearing opposition-only testimony. It's the fourth hearing they've had in this committee this two-year session, but they did hear testimony against our Article 5 application as well as our 34 ready bill. So, Andrew, that was a lot. Hot take. Oh, I think you're muted, maybe, Andrew.
There we go. I was saying, Rita, your head looks pretty good, so I'm guessing that you didn't beat it against the wall or the desk.
It was rough. It was hard at times.
So, wow, honestly, like my first impression on this whole thing was some of these people were really giving Publius Hulda a run for her money. Like, we needed some tinfoil hats. We needed, I don't know, some of the things that were just coming out of here at the beginning of the hearing were just crazy. So I'd be interested to hear some of your initial thoughts on what you thought.
Well, I took 2 pages of notes, Andrew. We promised the people, our viewers, that we were going to do some recap and rebuttal. We will try to keep it brief, though. We don't certainly want to go through the whole thing again. So we'll just go through them. They started with Dr. John Diamond, who made the claim that, as he calls it, a constitutional convention can't be limited. So I just have to point out for Dr. Diamond and everyone else watching that that's kind of like saying that because the Constitution gives Congress the power to declare war, that Congress can't limit a war to any particular country or countries, right? It only has the power to declare war, broad scale, full stop. That's it. War on everybody. It's really ridiculous. The power to apply for a convention includes, implies the power to limit the scope of the convention that they're applying for. We know that as a matter of common sense. We know that as a matter of logic. We know that as a matter of historical precedent. And we know from just tomes of various writings and quotes of the founding fathers that that's the case. Also, Andrew, Dr. Diamond seemed to be confused about what an Article 5 convention is, right? Because he was talking about it like we're going to rewrite the Constitution. Did you catch that?
Yeah, he said that, and there was a couple others that said the same thing. But yeah, and you know what's interesting is he also said that there's like no safeguards. Which what's ratification then? That's not a safeguard.
Yeah.
So.
Yeah, that was pretty nuts. Then we had Andrew. I know you enjoyed as much as I did. Ellen Horton, the teacher. I think she's Mrs. I don't want to refer to her the wrong way, and I don't want to be disrespectful. Mrs. Ellen Horton, the English teacher. And her whole argument is built up around this idea that Congress controls every aspect of the convention. And she kind of went to great pains to prove that Article 5 lets Congress control the mode of ratification. And we're like, yep, it does. Right? That's obvious. We all know that. We're good with it, right?
She even seemed to say like that they've never chosen a form of ratification, or that we wouldn't know if they would choose a form of ratification, even though we have 27 amendments where they chose the form of ratification.
Yeah. We're fully aware, Mrs. Horton, but thank you. Also, she did her sentence diagram, which I didn't get to see. You know, this is what I referenced at the beginning. We had the great sentence diagram last time. And her point with that seems to be that Congress calls the convention, which again, yep, that's what it says. We are not surprised by that. The issue is, and this came out with several of the witnesses, they think that the word call in Article 5 means control. And it really doesn't. And we know that because we know that words do have meaning. And we determine the meaning of words in the Constitution based on what they meant at the time the Constitution was written, right? And at the time Article 5 was written, calling the convention meant you say, you know, we're inviting the delegates from the other states to meet in this place at this time. That's the call. Yep, Congress gets to do that.
Which makes sense. It makes sense logically. Why would another state do? Why would one state out of the union get to do the calling?
Right. When it takes 34 of them agreeing on the agenda in order to happen, like someone has to be in charge of deciding when the 34 have happened.
Right. And so it only makes sense that it would be Congress and not one of the other states. So, I mean, just logically, you don't have to be a constitutional scholar to come to that conclusion that it makes more sense for Congress to do it. Anyway.
You really don't. So, Ellen Horton, you know, thank you. I'm sure you're a great English teacher and appreciate you. I'm sure you mean well, but that word doesn't mean what you think it means.
Sorry.
Yeah, sorry. Bless your heart. Okay. Moving on to Alicia Healy from the Ohio Patriots Alliance. She talked about her belief that the Constitution was divinely inspired. You know, Andrew, when people ask me if the Constitution was divinely inspired, I usually say it depends on what you mean by that. Again, words matter. Like, what do you mean by that? Certainly, it was not perfect, right? We needed an amendment to end slavery. That was pretty important. I'm glad we had an amendment to do that. What did you think about her testimony?
You know, divinely inspired. This is something that I always struggle with, because when I think about, you know, divine, I think about the Bible. I think about that's the written word of God, and it was divinely given to us. And you can't change any of that. That's when God says something, that's it. There's no changing it. The Constitution, though, like you were saying, it's been amended, it's been changed. And, you know, she brought up the quote from Benjamin Franklin He was giving a speech to his colleagues saying, if the laborers, or if God is not in the work, the laborers labor in vain. And he was petitioning his colleagues to pray, not necessarily saying that we need to get divine revelation from God for the Constitution. He was talking about going to prayer. So
Right.
I would agree with people that say that our founding fathers were men that relied on supplication to God. But I'm not going to go out and say that the Constitution is divinely written or divinely inspired. But that's just my own personal belief. So
Yeah.
I struggled with that just like you did with the divinely inspired, because it's been amended, which means it was not perfect, and it means
Right.
it had to go through changes.
Absolutely. Okay, then we heard from Joseph Healy. Is this her husband? I assume
I only
so.
assume so.
I don't
only
know.
assume so.
Yeah. And he, I'm not going to spend a lot of time on him because frankly, he was just kind of holding up these, so-and-so wrote this and so likes this Constitution, and like, okay, like, so what? Right.
I was trying to follow along. He was saying something about Woodrow Wilson liked this book, and this book was about changing the Constitution or something like that. So it's like, because Wilson liked this book, that means we can't ever have amendments, I guess. I mean, just some
He
of
lost
the.
me. Yeah.
I know he completely lost me. I'm sure that several of these testifiers lost the committee too. Well, except Representative Gross and a few others.
Okay, well, I have to think that they can't really have loved. I think it was this next one, Tom Rice, who was the.
Yeah.
I mean, how about that? That was something else, Andrew.
You remember John Kasich? He was like that with the hand waves. John Kasich was always animated when he was speaking. So
yeah. Well, Mr. Rice, or was it Dr. Rice? Representative Jennifer Gross wanted everybody who is an opponent to be a doctor. That seemed really important to her. So I don't know if Tom Rice is actually a doctor or not, but he made the point that, the Constitution already limits federal power. Well, okay. Do you not think it needs any more limits?
Right. What about when you usurp power that wasn't originally supposed to be for you? How about that?
He brought up the Runaway Convention, defaming the founding fathers, soundly defaming the founding fathers with his Runaway Convention claim. We have rebutted that so many times, Andrew. Michael Ferris has written a law review article for the Harvard Journal of Law and Public Policy that in many pages, meticulously documents why the Constitutional Convention was not a runaway convention. Then he brings up the necessary and proper clause. And I do want to address this because this came up with several witnesses that because of the necessary and proper clause, Congress has the power to control the whole thing, write all the rules. Well, unfortunately for their side, the case Idaho versus Freeman, which was actually referenced later, stands for the proposition that no, Congress can't use any of its other powers under the Constitution, including the necessary and proper clause, when it's performing its duties under Article 5. So necessary and proper clause is off the table for the convention. So that was kind of annoying to listen to repeatedly.
Mm-hmm. Yeah, he also brings up term limits are elections, and we've heard this line so many. And it's like a little soundbite thing, but when you think about it, it logically just does not make any sense. Because if term limits are elections, why is there an amendment to put term limits on the president?
Exactly.
Like, you don't have to be like a scholar to kind of come up with these questions and poke holes in their arguments. Like. And just like definitionally, they're not the same. I'm sorry. Like you want to say that you're limiting your representative by voting them in. Okay. But it's not the same as a term limit where you can only serve this amount of years. I mean, these shouldn't be hard things to grapple with, should they? I mean, I don't know. Maybe I'm crazy.
They're not, Andrew. I see that we have Bill Scott standing by. So I want to get to Bill Scott, but we just have one more, Robert Tuttle, and I just want to respond quickly before we go to Bill to a few of the cases that he brought up, because my concern about Robert Tuttle is he's well-spoken, he's articulate, and he sounds really authoritative because he's mentioning cases. But I just want to set the record straight on a couple. I'll just mention a couple. Dillon versus Gloss, which he mentioned, that case is all about Congress having the power to set a deadline for ratification. And the courts have said that that power to set a deadline for ratification is inherent or implied in their power to choose the mode of ratification. It makes sense. And it actually weighs in our favor when we say, yes, the power of the states to apply for a convention also includes and implies the power of the states to define the scope of the convention, limit the topics, choose their delegates. All of that is also implied in the state's power. So Dillon versus Gloss, not scary. Chiafalo versus Washington. This was interesting, Andrew, because I am actually counsel of record on that amicus brief to the Supreme Court in Chiafalo versus Washington. I worked closely with Rob Nadelson on that brief. And it's true. We suggested that the court limited its holding in the case because, frankly, we thought the decision was going to go the other way. We thought that the court was going to decide that presidential electors could not be constrained by state law. So we thought it would be a good idea to have the court limit its holding very narrowly. The court didn't decide that way and didn't limit the holding that narrowly. So of course, now we're going to use that precedent because it is good precedent for the point that we're using it for, which is the states can penalize their delegates who act as their legal agents when they go to a convention of the states to represent their state legislature. So just wanted to set the record straight on that. And with that, I know we only have a couple more minutes, so let's bring on Bill Scott and get his reaction.
Hey there, Bill.
Hi there. Hey, Andrew. Hey, Rita. How are you?
Hey.
We're doing all right. How are you doing, sir?
Well, I'll tell you how I'm doing. I had a choice to come today, or I could have gotten a root canal. I think I should have gotten my root canal today instead of rescheduling it.
Oh, man.
It might have been more fun. Oh, it was painful, but it was not unexpected. We have the usual cast of characters. They're familiar to us as they probably are to you and anybody listening. I just wish that at least 2/3 of them would introduce themselves, not with their name, but their organization, John Birch Society. They should put that in their introduction. They don't say that, but we all know them. So it was a long slog fest, and I noticed they took some shots at the COS legal department. So I didn't hear the first part of your commentary, but I'm hoping you guys have some answers to that, because it seemed like a pot shot to me.
Yeah, we did. It's easy to make people try to make people look bad by pulling things out of context and not telling the whole story, especially when you're talking to, lay people who aren't intimately familiar with the cases and the arguments. But yeah, it'll be okay. Bill, so we were amazed at your self-control and restraint. We could see you sitting in the hearing room, and we were very proud of you. You were very professional, but what do you predict happens next? Are you optimistic?
Well, I'm still optimistic that at the end of the day, this is all noise and, things that are meant to confuse, not to educate, and they won't remember 90% of what was said. They did have, I can tell you, we got the questions distributed to 4 representatives on the committee. And unfortunately, the vice chair, Ron Ferguson, could not make it today. And he's usually a good one. He's a good one for for questions. So we had others. Another one couldn't make it as well, Fazuli. So we only had 2 people with questions, and I think they wish they had more time to kind of dig into it, but they didn't ask as many questions as I had hoped. Except for Rep. Gross, of course, because she sounded like she was pretty well rehearsed.
She had a lot of questions.
Yes, and I believe they're all pre-rehearsed.
Of course they were. So, Bill, this was the 4th hearing. What's the next step after this?
Well, the next step, if we're fortunate and get a call for a vote, there may be no more testimony. Likely will be no more testimony. Although that's the option of the chair. If he felt there was, some votes that maybe got swayed or whatever, then maybe he will call for another hearing. But it would be another hearing where all parties are invited, proponents, opponents, and just interested parties. But we kind of think that may not happen if we can vote count, and if the chair can vote count and we have the votes to pass, they probably will pass on that. So that's what we're hoping.
All right.
And we're pretty close.
Bill, thank you so much for all your hard work. You do an incredible job out there with the amazing Ohio team, and we're very grateful for your efforts. Very proud of you. Thanks for being there today, and thanks for talking to us.
It's my pleasure. Have a good one, folks. Thanks. Good night.
Thanks, Bill. All right, Rita. Well, I think it's about time for us to sign off. I don't think I could handle any more opposition or debunking the craziness that we heard. So I think it's time for us to let our viewers go home and relax from the crazy hearing that they just heard. But make sure that you subscribe and share and catch all of the action at conventionofstates.com/COS live. Make sure you hit that little notification bell so that you don't miss a thing. You need to stay tuned because there's always great stuff happening during legislative session. You don't want to miss a hearing or any floor debate that will be coming up soon. There's more action left in this legislative season. Also, tomorrow night, Convention of States will be premiering a special investigative short film, The Story of the Ruling Class. This is going to be a good one. It premieres Wednesday at 8 p.m. Eastern Time on the Convention of States YouTube and social media platforms. Tune into Sunday night's Battle Cry with Mark Meckler. And if you want to ask Mark anything, go to conventionofstates.com/ask Mark. And don't forget to get involved with Convention of States. If you were watching this and you're like, I need to do something to push back against this disinformation, make sure you go to conventionofstates.com/act to get involved as a volunteer. All right, well, Rita, that's it for us. We'll be back with the next hearing or the next debate that we have. Thanks for tuning in. We'll see you next time.
Bye-bye.